Thank you. And finally, Mr. Taubman, you're recognized for 5 minutes.
Thank you for the opportunity to appear today. I have been practicing labor and constitutional law for over 42 years at the National Right to Work Legal Defense Foundation in Springfield, Virginia. My clients are individual employees who wish to stand apart from the workplace labor union they did not choose and do not want. For 42 years, I have helped litigate the Foundation's groundbreaking Supreme Court cases like Communications Workers versus Beck and Janus versus AFSCME. These decisions recognized individual employees' constitutional and statutory rights to partially limit their association with labor unions they wanted no part of, but were nevertheless forced to join or fund. Despite these Supreme Court decisions, I must regularly explain to my clients that while they can choose to join any house of worship, any affinity group, or fraternal organization that they want, federal law prevents them from choosing the agent that exclusively represents them in their workplace. And in half the states without right-to-work protections, they must pay union dues or be fired. But since October 7th, those once routine explanations of basic labor law have become dark, sobering, and often heartbreaking conversations about the reality of union anti-Semitism and legalized compulsion in the workplace today. Now my phone is ringing off the hook with calls from unionized Jewish and Israeli graduate students at this nation's elite educational universities. MIT, Columbia, University of Chicago, to name a few, asking me how they can disassociate from the union that is partnering with and often leading groups that organize protests to shut down the campus, destroy property, chant genocidal anti-Semitic slogans, and menace them on campus. Many of these employees are forced to pay dues that go directly to subsidize the union's celebration and support of Hamas's massacres. In case any of you need reminding, Hamas is a medieval death cult on the U.S. government's terror watch lists, not unlike ISIS and Al-Qaeda. Wearing masks at the workplace while chanting "Death to Zionists" from the river to the sea is not benign or legitimate union bargaining activity. My phone is also ringing off the hook from medical residents and interns at some of the nation's finest teaching hospitals, asking the same question as their union is busy poisoning their workplace with hateful and exclusionary anti-Jewish and anti-Israel propaganda. My phone is ringing off the hook from teachers and legal aid lawyers, all of whom wonder how the union they used to support and even champion had suddenly turned away from advocacy for better benefits and toward radical advocacy against Israel's just and moral defensive war, a war that is occurring thousands of miles away from their workplace. Federal labor law has long allowed employees to be trapped by exclusive bargaining agents they never voted for and do not want. But today, Jewish employees find themselves forced under the thumb of exclusive bargaining agents who are loud and ardent supporters of the Hamas death cult. At the National Right to Work, we are redoubling our efforts to help such employees forcibly saddled with anti-Semitic unions. We have filed Beck charges because unions falsely tell employees that they must join and must pay dues, even when the money is spent to support radical campus protesters. And we have filed charges of religious and ethnic discrimination with the EEOC because unions refuse employees' requests for religious accommodations. But despite our best efforts, Title VII and Beck are not nearly strong enough protections. As long as unions can force workers to pay anything to get or keep a job, employees will be denied their full freedom of association, speech, and conscience. The Janus decision was a small step for employee freedom in the public sector. Now is the time for this Congress to pass the National Right to Work Act in the private sector to end the problem of coercive forced unionism and the particular problem of compelling Jewish and other religious employees to fund unions whose views and activities are hateful, threatening, and deeply divisive. What could be more American than that? Thank you, and I look forward to answering your questions.
Thank you, sir. Under Committee Rule 9, we'll now question witnesses under the 5-minute rule. I will wait to ask my questions and therefore recognize Mr. Wilson from South Carolina for 5 minutes.
Thank you very much, Mr. Chairman, and thank you, witnesses, for being here today. And particularly, I'm very grateful, Mr. Taubman, the National Right to Work Committee has appreciated, is truly the champion for workers' rights, promoting freedom since 1955. That's just extraordinary to have such a strong life and so successful. And it's to achieve a majority of the American states to enact right-to-work laws for protecting workers' freedom of choice. In South Carolina, it was instrumental in working with creating 10,000 jobs at the Boeing Aircraft Company with its suppliers to build 787 jetliners several years ago in Charleston, Orangeburg, Aiken, and Lexington. I was grateful to be working with Governor Nikki Haley, U.S. Senators Tim Scott and Lindsey Graham, and Attorney General Alan Wilson with the Right to Work Committee, and you prevailed over the corrupt National Labor Relations Act, and now 10,000 workers, thousands of families are benefiting from what the Right to Work Committee has achieved. The Right to Work Legal Defense Foundation is working with Jewish and Israeli employees to protect their statutory and civil rights in the face of anti-Semitism. Can you discuss these workers' reactions to their unions supporting anti-Semitic and anti-Israel causes despite having a legal duty to protect the interests of all members they represent?
Thank you very much, Congressman Wilson, for that question. As I said in my statement, it is heartbreaking for me as a Jewish American and as a Zionist to have my phone ringing off the hook every single day since October 7th by students, workers, teachers, legal aid lawyers, doctors saying, how do I get out of this? I am surrounded by vicious people attacking me as a Jew, attacking me as a Zionist. I have friends in Israel. I have family in Israel. I have friends who served in the IDF, the most moral army in the world, perhaps second only to the United States Army, and they are attacked in their workplace. So that is the reaction that I am seeing. And unfortunately, I cannot say to all of these people, exercise your constitutional rights to get out, because under the National Labor Relations Act, they cannot get out. They are forced to be part of a bargaining unit and forced to pay dues to a union or be fired. And finally, although we've heard that unions have an obligation to tell people about their rights, in fact, few unions do. And if you look at the exhibits to my statement, you'll see that in Exhibit 5, for example, this is a pamphlet that the union at MIT put out to students. They say, you are required to sign up for either dues or agency fees as a condition of employment. The cost of dues and agency fees is exactly the same. That's a lie. The whole point of Beck is that the cost of reduced dues is different. You don't have to fund these obnoxious, outrageous political actions, but the unions lie and tell people they do.
Well, thank you for the Right to Work Committee for telling the truth.
Thank you. We'll now recognize Mr. Burleson for 5 minutes.
Thank you, Mr. Chairman. Mr. Sussman, in your testimony, you noted that the GSU, the Graduate Student Union, they illegally threatened to terminate anyone who refused to pay for their activism. You filed a charge against the GSU with the NLRB regarding them violating your Beck rights. While the NLRB did agree that your rights had been violated, do you believe that they addressed the issue adequately?
No.
Can you elaborate?
Sure. They required that the union send out a PDF stating our rights. And then the union officers continued to do exactly the same thing that they had been doing all along.
So they just continued. They're not doing any enforcement whatsoever.
That's correct.
Have you noticed other examples of politically motivated activity within the GSU that they pushed on their members?
They spend all of their time protesting against Israel.
I'm sorry, I didn't hear that.
They spend all of their time protesting against Israel.
Okay. So they're spending so much time pushing against Israel. Did they take any steps whatsoever to protect the rights of their Jewish members?
No.
That you can recall?
Not that I can recall.
That's tragic. Mr. Taubman, in your testimony that you say that since October 7th and the attack on Israel, labor unions have become organizers of hateful anti-Jewish and anti-Israel propaganda and resolutions. From the discussions that you've had with workers, and it's tragic to hear that you're getting phone calls from all over the nation, have unions, I'll ask the same question, have you seen where unions have stepped in to take steps to protect their Jewish members who are being discriminated against at this time?
Never once, and I have taken calls from all over the country, universities, hospitals, legal aid. Not one employee has ever said to me, oh, the union has helped me, or, oh, I can go to the union and they'll help me. None.
Mr. Taubman, I hesitate to bring this up, but there has been, I know that in my state, for example, there have been lawsuits and complaints against labor unions, particularly, we have areas where there are a high percentage of minorities, and yet the labor unions have a very low percentage of minorities in the single digits. And so there has been, there's often been a history, and I don't know if you have any comments about that. It's just the nature of this system to create that somehow emboldens discrimination within labor unions and the history of that.
Sure. I think the bottom line is the old adage, absolute power corrupts absolutely. If I can tell you, pay me or you're going to lose your job because I can get you fired, I would call that absolute dictatorial power in the workplace. And unions spend other people's money. Justice Scalia, in a Supreme Court case called Davenport, recognized that unions have a unique privilege in this country, the privilege of demanding other people's money, which they can then go use on all of these sorts of far-left, intersectional, woke politics, right? It's a lot more fun to go run around and riot on behalf of Hamas than it is to say, let's do a workplace grievance and see if we can get better wages in this place. Because that's boring, that's work. It's more fun to be, intersectional leftists.
Do you think the Beck decision was kind of a compromise rather than throw out? Because I think that the forced unionization is a violation of the First Amendment rights of association. So do you think that the Beck decision was a way to kind of split the baby and say you don't have to join, you don't have to be a member, but you still have to pay? And many of the examples are that you have to pay the exact same amount. And so the question is, do people truly have a right of an association?
Look, yes, and all of these decisions have been split the babies. If you go back to the original duty of fair representation decision, Steele versus Louisville and Nashville Railroad, where the unions were discriminating against black workers and refusing to let them join, the Supreme Court said, oh, we don't want to strike down the Railway Labor Act and these federal laws, so we'll create this thing called the duty of fair representation, and that'll fix the problem. Instead, they should have struck down these laws which violate people's free association rights. And we're going to continue to litigate to make that happen. And hopefully it'll happen in my lifetime.
Thank you for what you do, and I appreciate your comments.
Mr. Taubman, for decades you've litigated cases to protect the rights of individual workers who want to limit their association with labor unions who they want no part of. After the October 7 attack on Israel, was there an increase in the number of calls to you from workers seeking to associate from the union?
Thank you for your leadership, Dr. Fox. The answer is that my phone has been ringing off the hook, and my colleagues' phones have been ringing off the hook from doctors, from teachers, from legal aid, from people all over the country wondering how they can get out of these horrible anti-Semitic unions.
So what were the Jewish union members experiencing at their workplaces?
The other people on the panel, like Mr. Sussman, can tell you, because they're there on the front line. I can tell you anecdotally what I hear. Let me just read you from what some Jewish employees at CUNY, City University of New York, have said recently. Nails were found in their tires. Anti-Semitic flyers distributed all over the campus. Malicious and relentless campaigns to get them fired because they were Zionists. Discussions that observant Jews were undesirable for membership. Requests to remove observant Jewish faculty members. This is virtually Nazi-like from out of the 1930s. And that's what these people are seeing on their campuses.
Thank you very much. Mr. Sussman, your written testimony notes that in April, the Graduate Student Union at MIT pushed through a ceasefire resolution that does not mention peace, hostages, or Hamas. The divisive resolution passed with very low voter participation. Did the union ever seek out the opinion of Jewish graduate students who they represent before pushing this resolution forward?
They did not, and some Jewish students attended the general membership meeting where they discussed the resolution and asked the committee members who did they discuss the resolution with, and they said they looked inside themselves.
Thank you very much. I want to thank our witnesses for being here today to shed additional light on the anti-Semitism that is occurring within unions, and let the American people understand how deep, pervasive, and harmful this is to our Jewish citizens. Thank you, Mr. Chairman. I yield back.
In your testimony, Mr. Taubman, you mentioned how some American unions are now discriminating against and threatening Jewish workers, and that has been especially prevalent following the October 7th attacks on Israel. What legislative reforms do you suggest to Congress that we should consider to protect workers' rights with respect to unions?
Thank you for that fantastic question. Number one, certainly, is a national right-to-work law. This shouldn't be a state issue. This shouldn't even be a partisan issue. Nobody tells you you have to join a specific church or a specific group, or you have to pay money to a private organization. That doesn't happen anywhere else in American life except for the privileged labor unions that have been doing this since the 30s and the 40s. That's the first thing, pass a national right-to-work law. The second thing is, if you're not going to pass a national right-to-work law, there are things like recertification elections automatically. Every member in this room stands for an election automatically every 2 years, every senator every 6 years. Do you know how often unions automatically stand for re-election? The answer is zero. They never have to stand for re-election unless the employees can band together to throw them out. And in a place like MIT with thousands of grad students that rotate through for 1 or 2 or 3 years, that will never happen. Ronald Reagan said the closest thing to eternal life on earth is a government program. I can tell you the closest thing to eternal life on earth for these unions is to represent a bunch of graduate students.
Thank you. Dr. LaFaso, in your written testimony, you have a section about compelled union dues, and you note that under Beck, employees who work in right-to-work states can't be compelled to pay any dues or fees. I'm certainly glad that my state of Indiana is a right-to-work state so that people are not compelled to pay union dues or fees, even the cost of representation. However, you state that under Beck, employees who work in non-right-to-work states can only be required to pay their, quote, fair share of the cost of their representation. So my question to you is, what constitutes fair share for the cost of representation to an organization that is politically and ideologically opposed to some of their members' very being?
Well, under the under that question, they would not have to pay for any of those activities.
But they do have to pay for fees, is that correct?
They would, but they could also withdraw. They can withdraw, but by doing a Section 19 NLRB objection. So that means they would not have to pay any of those dues to the union.
It seems like, though, we've had some conflicting testimony to that today, that there are compelled fees that must be paid, and we will get to that. You also mentioned in your opening statement
that would be unlawful.
Sorry, I'm going to reclaim my time. You also mentioned in your opening statement that Congress and this committee should focus on real problems instead of what we're talking about today. Do you not believe that eradicating anti-Semitism from labor unions is a real problem?